President, distinguished members of the court. This part of the Gambia submissions returns to the clearance operations. I will respond to Myanmar's arguments on the three villages of Minji, Chutben, and Maungnu. Mr. Lowenstein will then address Myanmar's arguments in respect of the Tatmada's pattern of conduct in northern Rakhine State. Since we last addressed you, you have heard from the Gambia's three witnesses, each from one of the three villages. They have told you what they personally went through and saw. Their every word corroborates the determinations of the UN fact-finding mission report and other independent reports. What is Myanmar's answer? To say that these facts are not established and to invoke, yet again, counterterrorism. Nothing in what Myanmar presented last week can challenge the Gambia's evidence in respect of the unspeakable atrocities in Minji, Chutben, and Maungnu. Not its familiar nitpicking exercise, and certainly not its refrain of counterterrorism. Starting with Minji, or Tula Toli and Rohingya, Myanmar claims that none of the facts presented by the Gambia are established. The court will recall that these facts are derived from the determinations of the UN fact-finding mission, corroborated by independent reports from Amnesty International, the Holocaust Memorial Museum, Human Rights Watch, independent journalists, 3 witness statements from the IIMM, and 21 signed witness statements from Legal Action Worldwide. Myanmar has put no evidence before the court to refute those facts. Instead, it has leveled 2 challenges against the Gambia's evidence in Minji. First, it says, not a single word is said about ASA by any of the Gambia's witnesses, and therefore these witnesses are unreliable. Second, many of the Gambia's witness statements are anonymous and therefore without probative weight. Myanmar is wrong on both counts. The court will recall the harrowing account of witness MS from Minji. He gave a statement to Legal Action Worldwide in 2020 from which his name and identifying information were redacted. And it does not mention ASA. Yet Myanmar did not and could not challenge his testimony last week. Its criticism of anonymization, untested and unreliable evidence collapsed in the face of the evidence he gave before you in person. Not just because of what Myanmar admitted was an atrocity that he lived through, but also because his account aligns in every detail with the determinations of the UN fact-finding mission and other independent evidence, as well as the testimony of other Rohingya witnesses just like him. He described military everywhere surrounding the village from all sides, and the other side was only river. He described children being thrown into fires or into the river. He also told you that women were separated from the men, taken to houses, which was then set on fire. They included his wife and children, whom he never saw again. He further told you that his daughter was shot while attempting to escape across the river. Witness MS lost 6 members of his immediate family and 50 more of his extended family. Witness MS is only one of the 21 witnesses who provided a signed statement to Legal Action Worldwide. Those witnesses, too, described the modus operandi of the Tatmada in Minji. Surrounding villages, indiscriminate shooting, systematically executing men and boys, massacring children, raping and gang-raping women, and burning everything to the ground. If the court considers the testimony of witness MS to be compelling and gives it substantial weight, it should do the same for the remaining 20 witnesses from law whose statements were given in the same way. Myanmar asserts that the lack of contemporaneous mention of ASA by these survivors and witnesses, including witness MS, is, quote, contrived and intended to mislead and to deceive. Mr. President, did witness MS appear deceitful or misleading to you? Or can his account be somehow explained or justified by the presence of Asa and Menji? The answer is no. The Gambia has also put on the record 3 IIMM witness statements from Menji. Those statements mention Asa, and they also corroborate the modus operandi employed by the Tatmadaw and Menji. For example, witness 1477 recalled, quote, villagers fleeing towards the riverbank and military soldiers were pursuing them and shooting at them. Males raised their arms above their heads to surrender, but the military came close to them and shot them immediately. And all the houses where the military took the women set on fire. Witness P1301 recounted, I witnessed children who were scattered everywhere, being killed with knives and machetes, and snatched from their mothers and thrown into the fires, end quote. Myanmar claims an IIMM witness, quote, had lied in his earlier law statement about his knowledge and fear of Asa, yet his later IIMM statement is fully consistent with his earlier statement in respect of the Tatmadaw's modus operandi in Menji. Survivors focus on the atrocities that they observed. That is natural, and Myanmar's attempt to draw adverse inference from their silence on Asa is frankly irrelevant. Myanmar devoted much time to a description of alleged Asa activities in and around Menji. Around more than in, perhaps, because its claims of, quote, heavy Asa presence pointed to a place 10 kilometers from Menji. The presence of Asa there and in other villages, none of which were Menji, in the days and weeks prior to 8 a.m. on the 30th of August 2017, does not somehow render the Tatmadaw's attack on Menji responsive. The UN fact-finding mission identified just 2 Asa attacks in other villages in the vicinity of Menji, but these were several days earlier. And in response, the Tatmadaw had already conducted 2 separate clearance operations. The mission recorded no armed engagement with Asa on the day of the clearance operations in Menji. Myanmar says otherwise, claiming that there were repeated clashes with groups of hundreds of Bengalis in Menji. What is the evidence to support this? Myanmar only has its own military operational reports and statements from its own military officers. Professor Newton told you that military reporting of this kind is inherently unreliable and has no probative value unless it is corroborated by independent external examinations. Myanmar has no independent corroboration here. Mr. President, members of the court, I now turn to Chutpin, or as the Rohingya know it, Shrop Parang. Myanmar again says that the evidence, the facts presented by the Gambia are not established, despite being grounded in the UN fact-finding mission's report, independent reports from Amnesty International, Physicians for Human Rights, Fortified Rights, the International State Crime Initiative, as well as more than 20 witness accounts from law and 4 signed witness statements from the IIMM. Again, Myanmar has offered no evidence to contradict these facts. Myanmar resorts to its usual attack on the so-called contrived silence on Asa in the law witness accounts, as well as their anonymization. One such witness account is that of witness NJ, from whom the court heard directly last Wednesday. Such a witness, every detail of her testimony corroborates the determinations of the UN fact-finding mission and other evidence from Chutpin in respect of the modus operandi employed by the Tatmadaw in Chutpin. She told you that the military tortured and took away her husband and father-in-law, whom she never saw again. She told you that a soldier grabbed her infant son from her arms, stabbed him with a knife, and threw him into a fire. She told you she was gang raped. She told you she felt they wanted to destroy as a whole the Rohingya community. She also told you that the military burned the whole village. Witness NJ is one of more than 20 witnesses from Chutpin whose experience was captured in a summarized account by law, which Myanmar criticized as unsigned, anonymous, and should be given no probative weight. You have heard her live testimony. It showed that the law's interview note with her preserved the substance and detail of the underlying evidence. The court, therefore, can rely on those interview notes. Myanmar asked witness NJ during cross-examination about ARSA. She said, quote, she had no idea about any of these names and therefore didn't talk about them. Was there anything deceitful about witness NJ, a mother who never left her village, who spent her days caring for her children, to not know about ARSA? You heard her say her fear was not ARSA, but the reach of the Myanmar government. Quote, Bangladesh camps are very close to the Myanmar border, so I had the fear that the government might reach and come and kill my family members. End quote. Counsel for Myanmar surprisingly claims that the Gambia, quote, avoids the IIMM witness statements from Chutpin because it, quote, reveals a quite different picture of the military's conduct, even while acknowledging that the Gambia submitted 4 IIMM witness statements for Chutpin. Mr. President, in reality, the picture is not that different. Every IIMM statement in evidence, including the 2 introduced by Myanmar, describe the same modus operandi employed by the Tatmadaw and Chutpin, as documented by the UN fact-finding mission and other independent investigations. Mr. Reichler took you to these statements earlier, but he has not read you this passage from witness P135, the witness that Myanmar trumpeted for saying that military do not attack ladies and let people go to Bangladesh. Quote, I saw a lady whose breast was cut and who died instantly. I saw that she was taken by the militaries. When she tried to resist, I saw that a man came, held one of her breasts and chopped it off. She started bleeding a lot and screaming, and the militaries shot her from a distance. Hardly an account that exonerates the Tatmadaw. In a now familiar pattern, Myanmar turns to counterterrorism as its mantra for justifying the atrocities in Chutpin. What Myanmar never explains is why the events it relies on, occurring in locations some 10 kilometers from Chutpin or otherwise outside of the village, could provide justification for what happened in Chutpin itself. The only incident that Myanmar locates in Chutpin is the attack on the Chutpin police by, quote, a member of ARSA from Chutpin Bengali village with homemade bombs. The fact-finding mission was unable to verify this attack. Myanmar's answer is simply, trust our own military operational reports, our own military witnesses, and statements from detainees in our own custody. You heard from Professor Newton about the reliability of such evidence. Absolutely unreliable and has no evidentiary weight. Even if it is assumed that the attack on Chutpin police by ARSA did occur, Myanmar has no answer to the conclusion of the UN fact-finding mission that plans for a clearance operation in Chutpin appear to have been made prior to this incident, nor for the way in which it was conducted, a modus operandi that speaks not of counterterrorism, but of genocide. Mr. President, I finally address the village of Mangnu, or Monopara, in Rohingya. As with the other 2 villages, Myanmar has produced no evidence to contradict the determinations of the UN fact-finding mission, corroborated by multiple sources, including Amnesty International, the International State Crime Initiative, the United States Holocaust Memorial, signed witness statements from the IIMM, Fortified Rights and Law. Counsel for Myanmar simply says these facts are not established, complaining once more about the Gambia's reliance on, quote, anonymous summary hearsay notes. Yet you have heard from witness MN, who was once such an anonymous witness. He stood before you and described how soldiers opened fire in Mangnu and separated him from his wife and children at gunpoint. He recounted being rounded up with other men and having his hands tied. He told you how soldiers kicked him in the back and neck, forcing him to lie face down on the ground. From there, he heard the voices of other men crying out to God. Then came the gunshots. Witness MN then recounted the scene that haunts him to this day. Piles of bodies, more than 60 men and boys, stacked together in death. Among them lay his elderly father and his 8-year-old nephew. In answering Judge Gladi's question on whether any of the 87 men with whom he was captured survived, he said, none of them. That testimony is consistent with the fact-finding mission's indication that, quote, up to 100 people, mostly men and boys, were executed in Mang Nu. Professor Newton told you, the modus operandi of segregating and executing men and boys reminded him of Srebrenica. None of this testimony has been challenged or disproven by Myanmar's counsel. Equally false is Myanmar's assertion that the IIMM witness statements concerning Mang Nu contradict the Gambia's evidence. On the contrary, they confirm it. For instance, the statement by witness P1493, introduced by Myanmar, recounts how, quote, the ground was wet with blood in Zahid Hussein's compound. The witness describes seeing the dead body of a child aged about 2 years old, with one part of his head missing. A different statement, also introduced by Myanmar, describes the killing of another boy, adolescent, maybe between 14 and 16, who was shot in the head by a soldier that half of his head and brains were blown out. Last week, Myanmar argued for the first time that the clearance operation in Mang Nu was a targeted strike on, quote, ARSA cell leader Zahid Hussein and his home address. That, of course, is a significant claim. Myanmar's single source of evidence is a statement from the IIMM, the very body whose materials Myanmar dismisses elsewhere as having no evidentiary weight. Be that as it may, Myanmar's new argument changes nothing. The evidence plainly shows that the clearance operation in Mang Nu was not targeted. If the objective was to eliminate an ARSA leader and his affiliates, one would expect the operation to end with the arrest and detention of select individuals and with the separation and protection of civilian population. What transpired instead was an indiscriminate mass execution, including of children and the elderly. Myanmar Council asserts that ARSA militants began to assemble in Mang Nu itself throughout the 26th of August, but it offers no citation in support. It is not disputed that there was no documented ARSA attack in Mang Nu on the 27th of August before the security forces arrived. What prompted the Tatmadaw to descend upon Mang Nu was not an attack on the village itself, but an uncorroborated suspicion that ARSA members from nearby village Hapong Tolpen could be hiding around Mang Nu. In its opening presentation, Myanmar alleged additional ARSA activity in the surrounds of Mang Nu. It is telling that just as with Minji and Chutpin, Myanmar must resort to peripheral events taking place somewhere at some distance to justify what transpired in Mang Nu. In reality, the Tatmadaw's arrival in Mang Nu was not related to any ARSA attack. It was part of a rolling wave of clearance operations across Rohingya villages. The Tatmadaw terrorized one Rohingya village, driving its residents to flee to another village. It then used that displacement as a pretext to launch additional clearance operations in those surrounding locations on the ostensible basis that fleeing civilians included ARSA terrorists. This self-generating logic, attack, displace, and attack again, reveals the true nature of the operation, not to neutralize any security threat, but to destroy an entire community. Mr. President, members of the court, I conclude by responding to 6 points raised by Myanmar's counsel in its opening presentation on the 3 villages. First, Myanmar claims that the use of force by Myanmar Defense Services was directly responsive to ARSA-led violence in northern Rakhine State. As we have demonstrated, Myanmar has offered nothing but its military documents to prove this in respect of the clearance operations in Minji, Chutpen, and Maungnu. Counsel for Myanmar asks, rather ironically, and I quote, "One wonders how then the Gambia envisages any state might defend itself in proceedings such as these if it could not rely on such self-serving and unreliable evidence." Professor Newton already answered this. Corroborate your military reports with independent and external examinations. Even if we were to accept Myanmar's clearance operation in the 3 villages was somehow responsive to ARSA attacks, what was its response? A modus operandi of encircling villages, indiscriminate shooting, segregating and executing men and boys, massacring children, raping and gang-raping women and girls, comprehensive burning of Rohingya settlements while leaving the nearby Rakhine areas intact. This, as Professor Newton has now testified, cannot simply be described as disproportionate uses of force by the Tatmadaw. It was part of an extermination campaign to destroy the Rohingya group. Second, Myanmar trumpets its rules of engagement, which it claims were distributed to security services before the clearance operations. But as Professor Newton observed, and I quote, "The Tatmadaw published rules of engagement. They disseminated them to troops. Then, with respect to this portion of the population, they engaged in that sustained modus operandi from start to finish, which not only was not compliant with those rules of engagement on an aberrational basis, it simply ignored that they existed." End quote. Third, as Mr. Reichler demonstrated, the Gambia evidence in respect of the clearance operations, including in the 3 main villages, is independent, reliable, and compelling. The 3 witnesses who spoke before the court last week confirmed this beyond any doubt. Fourth, Myanmar attacks the Gambia's fatality figures in the 3 villages because they, quote, "do not accurately reflect the evidence." While the figures the Gambia put forward are necessarily estimates, they represent the best available numbers in light of the nature of the clearance operations, during which the fact-finding mission found that people were killed without witnesses. Their bodies were subsequently and systematically disposed of. Finally, Myanmar is wrong to claim that the events in Minji, Chutpen, and Maungnu were not typical of events during the clearance operations in northern Rakhine State. The UN fact-finding mission found the same modus operandi in a total of 54 separate locations, with evidence extending to at least 20 more. Mr. Lowenstein will address you on that next. Mr. President, members of the court, I thank you for your kind attention. May I ask